I'm going to call this meeting to order as members take their places. This is our 107th meeting of the Standing Committee on Citizenship and Immigration, and we are continuing and perhaps even concluding our study of the Immigration and Refugee Board's appointment, training, and complaint processes. I want to thank Ms. King, who is the Registrar at the Justices of the Peace Review Council in Ontario, for joining us today. And a little bit, I'm sure you've been told the background of this is that we are looking, we've been looking at training, we've been looking at the process of appointments, but particularly looking at the complaints process. We recognize the difference between judicial bodies and quasi-judicial bodies, administrative law bodies, and that, but we were looking at the different systems of complaint processes that could inform our examination of the current system that is at the IRB right now. So thank you very much. You're our only witness today. And to give you a little bit of a break, we'll probably do about 45 minutes, have a presentation from you, and then questions from both sides of the House, and then we'll see where we're at from that. So you can take it away with an opening statement of up to 7 minutes.
Thank you, Honourable Chair, and good morning, Honourable Members. Thank you for the invitation to have a representative of the Justices of the Peace Review Council attend before the committee. As the Chair indicated, my name is Marilyn King. I am the Registrar of the Review Council. I'm a lawyer, and I have a history of public service that's included positions such as a Crown Attorney, Executive Director of a community legal clinic providing services to low-income clients, and I've had various financial, policy, and operational roles in the justice sector, and I have been the Registrar of the Review Council since January of 2008. And I'll just give you a brief overview of the Review Council and its role, and I believe you've all been provided with the annual report and also with the brochure that's provided to members of the public through various places. So there's more detail in there, but just briefly, given the role of the Justices of the Peace in the administration of justice, they are expected to be sensitive to the high expectations of the public that judicial officers will remain worthy of trust, confidence, and respect. And in that context, the Review Council was established by the Justices of the Peace Act as an independent body to receive and investigate complaints about the conduct of Justices of the Peace. The current composition of the Review Council and its legislated responsibilities were established in 2007. The objective of the Review Council, like other judicial discipline bodies, is to preserve or, if necessary, restore public confidence in the judiciary in general. Case law in the courts recognizes that judicial discipline bodies must determine the appropriate disposition that preserves or restores not just the integrity in the individual justice of the peace, but also in the integrity of the whole of the judiciary. In terms of membership, to carry out its role, the Review Council must respect judicial independence in judicial decision-making while providing a means for accountability for judicial conduct. The Review Council has members with knowledge of judicial decision-making and the nature of judicial independence and the work being carried out by Justices of the Peace, as well as members who can provide input from the perspective of the public. The members who review and investigate complaints and determine the appropriate disposition are 3 judges of the Ontario Court of Justice who are appointed by the Chief Justice, 1 Regional Senior Justice of the Peace appointed by the Chief Justice, 3 Justices of the Peace appointed by the Chief Justice, and 4 community members appointed by the Lieutenant Governor and Council on the recommendation of the Attorney General. There is also 1 lawyer appointed by the Attorney General from a list of 3 names received from the Law Society of Ontario. The Act also states that in the appointment of members, there is an importance in reflecting Ontario's linguistic duality, the diversity of the population, and ensuring overall gender balance. In investigating, any person can make a complaint to the Review Council about the conduct of a Justice of the Peace. Complaints must be made in writing, and there is no mandatory form used. Any letter can be written. The legislation requires that the investigation be conducted in private, and that is unlike the stage of a hearing, if a hearing is ordered, which is generally public. Each complaint is assigned to a 3-person complaints committee that includes a judge, a Justice of the Peace, and either a community member or the lawyer member for investigation. If the complaint arises from a court proceeding, court transcripts and audio recordings of the proceedings are ordered and reviewed by all members of the committee. And if the allegations relate to conduct outside of the courtroom, an independent lawyer may be retained to interview witnesses and provide the copy with a certified transcript of any interviews. A written response may be invited from the Justice of the Peace, and if so, he or she is provided with full disclosure about the complaint and the information under consideration by the committee. A Justice of the Peace can retain a lawyer to assist in responding, and at the end of the process, can request compensation for their legal costs. The committee makes a recommendation to the Attorney General, and it's within the discretion of the Attorney General as to whether or not to pay the amount recommended. When a Complaints Committee's investigation is complete, it has a range of dispositions available to it. They can dismiss the complaint. They can provide advice to the subject of the complaint, either in person or in writing. They can order a public hearing, or they can refer the complaint to the Chief Justice with conditions such as education or treatment. The Act provides that the Review Council can establish rules of procedure to guide its complaints committees and its hearing panels, and it has actually developed those procedures, and they're available on the Review Council's website, available to the public. The Review Council uses those criteria in the procedures to guide the committee on whether or not a hearing should be ordered and what the appropriate disposition is. A hearing will be ordered if the Complaints Committee believes that a finder of fact could find that the Justice of the Peace engaged in judicial misconduct. The Act does not define judicial misconduct, but cases have held that the test for judicial misconduct is whether the impugned conduct is so seriously contrary to the impartiality, integrity, and independence of the judiciary that it has undermined the public's confidence in the ability of the Justice of the Peace to perform the duties of office or in the administration of justice generally, and it is necessary for the Council to impose one or more of the dispositions that I've indicated in the legislation in order to restore that public confidence. If a hearing is ordered, it is heard by a hearing panel of 3 different members, again, a judge, a Justice of the Peace, and either a community or a lawyer member, and those members cannot have been the members who were involved in the investigation of the complaint. Notice of the hearing is posted on the website, and it's put in the newspaper where the complaint arose. An independent lawyer, called presenting counsel, is retained to present the evidence to support the allegations that are set out in the complaint that goes in the notice of hearing, and the Justice of the Peace or his or her lawyer may also present evidence. After a hearing, if there is a finding of judicial misconduct, the possible dispositions include a warning, a reprimand, an order of an apology, an order of specified measures such as further education or treatment as a condition of continuing to sit as a Justice of the Peace, a suspension without pay for up to 30 days, a suspension with pay, or if not any of those, a recommendation to the Attorney General for removal from office. To recommend removal from office, the hearing panel must determine that the conduct of the Justice of the Peace is so manifestly and contrary to the independence, impartiality, and integrity of the judiciary that the confidence of individuals appearing before that Justice of the Peace or of the public in its justice system would be undermined, rendering the Justice of the Peace incapable of performing the duties of his or her office. So in summary, public confidence in the administration of justice is viewed to be of paramount importance. Justices of the peace are, for many members of the public, the first experience and often the only experience in the justice system, and they are the face of justice. The complaints process carried out by the Review Council therefore has a role in maintaining and restoring public confidence in the judiciary and in the administration of justice. Thank you. I tried to keep that to 7 minutes.
Thank you very much. That was very helpful. And thank you for your public service. And I also recognize that it's not in your job description to appear before a House of Commons Standing Committee, and yet it's very helpful for us. So thank you for doing that. Ms. Alslav for our first questioning.
And I'd like to echo that, but thank you very much, because this really does give us a clear perspective on what an alternate type of review board looks like. My first question, if I could, is around the fact that yours is an independent review board. Could you give us some idea of why that's important? And any advice you would give us on how to determine what criteria should we be using to determine whether this process or a board like a review board should be independent or within the system?
Well, in the case of the Justice of Peace Review Council, it in particular should be independent of the government. The government should not be perceived to be influencing the outcome or having any role in what the outcome is. So it is independent of the government, and that is why the Chief Justice appoints some of the members. And although the Attorney General and the Lieutenant Governor and Council do play a role in appointing community members, that is because that process is, to my understanding, done through the Public Appointment Secretariat, which probably also exists by analogy in the federal system. And the Law Society, of course, puts forward 3 names. So the Law Society is effectively doing a preliminary screen. So it does put, the result of it is that the people that are investigating complaints and making the decisions on the complaints are doing that independently and based on the input they bring from their various backgrounds, but not controlled by any person. And the other layer that supports that independence is the confidentiality of the process, which has, in fact, been challenged by the media. Toronto Star challenged it recently in another body that I support that's analogous to this one. And the confidentiality of the process means that, for example, even though the Chief Justice has a role in appointing members of the bench to the body, she does not have knowledge of complaints that come in the door unless a public hearing is ordered or unless a disposition is a referral of a complaint to her. So confidentiality in the process supports that independence. And I think that, I mean, my experience has been in the 8 years, I guess it's been 8 years that I've been there, that having the body making its decisions independently, but also having their procedures public so that people know what's happening, and also having an annual report, like the annual report, when you have an opportunity to look at it, does provide case summaries on every complaint that comes in the door. If it's not ordered to a public hearing, there are still case summaries provided. And my experience has been, because I actually have participated in a group of lawyers that do what I do in the States, and my experience has been that the annual report put out by the Review Council provides comparatively fairly high degree of detail on the nature of complaints that come in the door. So when you have an independent body making decisions, everyone knows the kind of people that are on the decision-making bodies, the complaints committee and the hearing panel, and everybody knows if they read the annual report, the kinds of complaints that come in, how they are addressed, the reasons for why they're addressed. That all supports the public confidence of the process. Whereas if it's in some provinces, they don't have a body set up like this one. And if it's simply a complaint goes to a Chief Justice, those additional supports to preserve or restore public confidence, in my opinion, respectfully, aren't the same. I don't know if that answers the question.
It absolutely does, because what you've done is you've given us a reason for it being independent, but not public, but at the same time transparent, if I understood you correctly, because by publishing the procedures, the composition, and having 3 separate bodies choose the composition in a way, and then the code of conduct and the sanctions, and then an annual report, you're addressing the requirement for transparency as well as independence, but still keeping the process confidential. Did I get that right?
I would just add a couple of things to that, that the process is confidential unless the threshold is reached where a public hearing is ordered. So if
I meant procedures, the procedures are public.
Like yes, and a hearing, if it's a serious enough complaint to warrant a hearing, the hearing is public. So right now, for example, I think we have 3 or 4 public hearings that are underway.
And there's
So
a certain
those-
threshold that determines
Yes.
whether or not, and that's brilliant. So now if I
Yes.
could talk about the composition of the panel, because you've stated it's not one person, and often it will have a community member or honest broker on it. Can you give us some rationale for why that's important in terms of maintaining the public confidence?
Yes, it always has three at the investigative stage, a different three if it's serious enough to warrant a hearing. It's important to have someone on the each of those bodies, which the judge and justice of the peace do. They provide an understanding of the work of the person that's being complained of, for example. But it's very important to have community input. So the lawyer or the community person, whichever the third person is in the committee or on the hearing panel, in my experience, do bring valuable input from the members of the public. And the other members, again, in my experience, very much seek out and value the input from the community member as well, because sometimes the judiciary may see it from the perspective of what the justice system is to them on a day-to-day basis, whereas a member of the public might have a different perspective because they're not as familiar with the justice system and they're seeing it how a member of the public would see it. So having a member of the public on it, whether it's the lawyer or whether it's one of the other four community members, in my experience, is very valuable.
Fantastic. And then could you give me some idea? It's an unfair question to ask you, but you are the expert. What would you say are perhaps some of the areas you would like to strengthen in the review council process? And therefore, what recommendations would you make to us in looking at that kind of complaints review process?
Very briefly, if you have anything.
Well, I'll just tell you how we do strengthen it. Because we do have some hearings that go on, in the course of hearings, and sometimes not hearings, but usually in hearings, they tend to be represented by lawyers. So issues may arise that show something in the procedures that could be improved, refined, or clarified. So the procedures are basically viewed to be like a live document. And if a deficiency or a weakness is noted in the procedures, they aren't locked in stone. So the legislation provides that they have the authority to make the procedures, but the procedures are up to the council.
Excellent. Thank you very much.
Mr. McGuire.
Thank you, Mr. Chair, and I'd just like to welcome to your for your testimony, Ms. King, as well.
Thank you.
I'd just like to say that I was particularly interested to hear that the justices of the peace have panels to hear these complaints, as you've pointed out, made against them. And do you think that this system is preferable to having just the chairperson hear complaints, as is the case with our IRB?
I apologize. I only learned about this on Friday, so I didn't have a chance to research what your structure is. So I'm sorry that I don't know that. Had I had time, I would have researched that. My experience is that having the input of three people with different perspectives is beneficial. At least from what I see, they do have different perspectives on it, and it can be complicated in terms of what scenarios might come in the door. It can be complicated. So, I mean, the other thing that this does is it keeps in our case, the Chief Justice is preserved from the process. So one of the potential dispositions can be a referral to the Chief Justice, who meets privately with the judicial officer and can discuss the concerns of the committee, and that can be a very remedial educational step. If she were dealing with all of the complaints, it would be harder to communicate back to the members of the public what happened with it, some of the feedback that comes back out of that meeting. Having the body independent of the Chief Justice allows for that type of a remedy, but it still allows for the body to provide that information back. If the Chief Justice were dealing with all of the complaints, I can't speak for your process. I can only speak for my own. It would be so much more difficult to provide the degree of information and feedback back to the public to be transparent about what went on.
Thank you. So do you think that the creation of the Justice of the Peace Advisory Council has improved the quality of the appointments at the Justice of the Peace?
Well, At the same time as this format of the Justice of Peace Review Council was established in 2007, the appointments process was also changed and a more rigorous process was put in place. But in the time that I've been there, I certainly have seen hearings occur, and I've seen all of those dispositions pretty much be implemented. So I have to have some confidence that the process is working. And if a justice of the peace is given an opportunity to alter their conduct and they come back for a second hearing, then, which actually happened recently twice, then that actually does show that there's still a process there and there's still a remedy there for it to come back. So the public would say the process isn't perfect, but my perception is that it is effective.
And so what is the advantage then of having a Justice of the Peace Review Council?
What is the advantage?
Yeah, versus...
It provides a structure to inform the public. Well, it provides a remedy for the public if they're concerned about the conduct of a justice of peace. It provides a remedy to make that justice of peace accountable, and it provides dispositions to alter that conduct. It provides an educational platform, if you like, so that other justices of peace know the expectations of what their conduct should be, because when we put out the annual report each year, we send a copy of that annual report to every justice of peace sitting on the bench so that they have the opportunity to be educated as well. But I think the primary thing is it provides a framework for accountability for judicial conduct that otherwise would not be there.
Thank you. And so how much information about complaints against the Justice of the Peace's situation are made publicly available?
How much information about the complaint?
Yes, about the complaints.
Well, so for example, I don't know if you were provided with the annual report, which I did send the electronic version of. So for example, I'm just, by way of an example where there's a complaint here, it doesn't name, if it was not the threshold to order a public hearing, it still provides the information on that a complainant made a complaint, what kind of court she appeared in, what the allegations were of what the conduct was. And in this case, for example, the Justice of Peace believed that the complainant believed the Justice of Peace was unfair and racist and ignored her and so on. All of that would be set out. The steps taken by a complaints committee are set out. So it would say the complaints committee ordered the court transcript or had witnesses interviewed. And if it's not dismissed, it will disclose that the Justice of Peace was invited to respond. Some information of what they responded would probably be included in the case summary. The disposition is there, the reasons for it are there. And if the committee had concerns because of the principles of judicial office that were not upheld by the Justice of Peace, that information is there. So this particular case summary that I'm looking at, for example, is about 2.5 pages. And it varies by complaint and by complexity of the complaint. If it's a hearing, all of the decisions made by the hearing panel are public, and the hearing itself is fully public as well. Basically, the open courts principle applies if it's a hearing.
Thank you. We've dealt a great deal, I guess, in this committee and in hearing testimony throughout the past months that there's a sensitivity that's required by members in regards to the panels and the appeals. So how much sensitivity training do Justices of the Peace receive in regards to their role?
I actually can't speak, because I don't oversee their training, I can't speak to the details of it, but the education plan for Justice of Peace is actually posted on the Review Council's website. And my understanding is that the Justice of Peace do receive very extensive training since 2007, extensive training when they are appointed to the bench. And when you say sensitivity training, I'm not sure if you're meaning like so that you won't conduct yourself in a discriminatory manner, or...
Well, that's part of it, but it's also, pardon me, that's part of it, thank you, but it's also to deal with the, like we spent a good deal of time saying, whether the panel should be made up of lawyers, how much training should you have as a member in regards to the law, in regards to it, or is it more just what the member might expect or through their lifetime experiences add to that role. And so I guess I'm just wondering, some of them may have never been in a situation like that. I'm just wondering if the Justice of the Peace receive any kind of training in regards to that role that we could use as a reference here.
So if they are, again, I'm sorry to have to clarify, Justices of Peace who are sitting on the Review Council and dealing with complaints?
Yes.
Yes. Every member of the Review Council, whether Justice of the Peace, a judge, or a lawyer or a community member, receives orientation education when they join the council, whether they're on a hearing. They get it again when they're going on a hearing, and covering the nature of, I guess, just an overview of what the process is and explaining the criteria and reminding them of what the law is for the threshold for a hearing being ordered, and they're provided with some relevant case law. So every member gets orientation education regardless of their background.
I'm afraid I need to cut you off there. Ms. Kwong, you'll have about 8 minutes.
Thank you very much, Mr. Chair, and thank you, Ms. King, for your testimony. I am wondering, how are community members or community representatives on the panel chosen?
My understanding is that they apply through a public website, the Public Appointments Secretariat, and I'm not involved in that interview process. So I know that they have to provide their resume, and I believe they have to provide references, but it's through the normal Public Appointments Secretariat process. And then I'm informed of who the members are, so I don't have input into who those people are.
I see. So a pool of people then are selected through that process, and then for each of the complaints, they just get assigned to the.
Oh, I'm sorry. I
misunderstood.
misunderstood you. I'm sorry. Through the Public Appointment Secretary, they're appointed to the council, so there then are 4 of a pool to select from for the community members, and they're assigned to investigate complaints based on various criteria. So, for example, where did the complaint arise? We avoid assigning complaints to members who work in or live in the area where a complaint arose from, so that they would be perceived to be more neutral and objective. And caseload determines it, so we just try to make sure that everybody has an equal number of them as well. And then, of course, if it's ordered to a hearing, they are eliminated. If they've been on the investigation, they cannot be on the hearing panel. But it's geographic and caseload really are the critical things.
Okay. And in determining the seriousness of the complaint, so therefore in determining whether or not it goes to a public hearing on the threshold, how is that threshold made and who makes it?
The threshold is actually set out in the procedure so the public knows what the criteria is, and the committee decides whether that criteria has been met by conducting the investigation, considering the evidence gathered during the investigation, and then if they feel that they believe the threshold set out in the public procedures and the criteria has been met, then it's ordered to a public hearing.
See, so then you meet full transparency and accountability so that people know here's the threshold. If you violate this threshold based on an independent investigation, then this is how it is going to proceed accordingly.
Yes.
Okay. That's very helpful. Now, in terms of a situation where a complaint has been found, right, against a particular individual, and let's say some sanctions has been put in place, whether it be additional training or whatever that remedy might be, what process do you go through to ensure that the remedy or the additional sanctions has been effective? What kind of evaluation and follow through, if any?
There isn't evaluation to see if it's been effective, but there is. So, for example, if it's some of them, I guess the only one I can think of that would apply to would be if there were further training or treatment or counseling ordered. Generally, that is assigned through a public order for the Chief Justice to take steps to ensure that happens. And then the Chief Justice does report back to confirm that those steps were taken. Or if it's an order of an apology, the apology is always communicated in writing through our office. And then we communicate that to the complainant or the person affected by the misconduct just to ensure that everyone knows what the apology was and it was appropriate and that it did take place. But in terms of the other remedies, so for example, if it was a suspension for 30 days or less, then I guess the way it's known to be if it's effective is if we get another complaint about them. So for example, there was a former Justice of the Peace who had a public hearing and further counseling and training was ordered. And we had another complaint, and following the second hearing, he was removed from office.
I see. Okay. In terms of the outcome of the complaints, is it the case that only the outcomes where it is through a public hearing that the remedies assigned would be made public, and all the other cases, if they have not met the threshold, then that would be kept confidential?
No, that isn't correct. The annual report includes every complaint that comes in the door that's within the jurisdiction of the council, even if it's dismissed. It's described in there. The legislation does not permit, if it's not ordered to a public hearing, the legislation says that the names of the complainant and of the Justice of the Peace are not made public because a hearing was not ordered, that threshold wasn't reached. But a case summary for every complaint is provided in there. And in addition to that, at the end of the complaints process, even if it's a dismissal or if it's advice or whatever, the complainant receives a letter in writing to inform them what happened on their complaint. But every complaint, there's public information.
I see. And in terms of dismissal or the range of sanctions, do you have a list of the sanctions that may apply or that you can share with the committee with respect to complaints?
Yes, the list of dispositions is what I had indicated, where it's either a dismissal. So if there's no merit to it, or it really isn't, it doesn't amount to really much. It's and a lot of them are decision-based as well. They really want to change the decision. There's no real conduct there. Those would be dismissals. Or if it requires, it doesn't reach the threshold for a hearing, but it requires some remedial step, there may be an advice in person or an advice letter that goes to the Justice of the Peace, or it can be a referral to the Chief Justice, which is viewed to be a significant disposition where you have to go and meet privately with the Chief Justice, possibly with conditions, or an order for a hearing. Those are the first step. And then if it goes to a public hearing, it can be a warning, a reprimand, an order of apology, further measures like education or treatment, a suspension up to 30 days with no pay, a suspension with pay, or a removal from office. A recommendation to the Attorney General for a removal from office.
Okay. Timeline for the complaints. What is the general timeline for a complaint to be investigated and so that people can know what the outcome is?
Yes. I'd have to say we've never measured that because it really varies. If it's a very straightforward one that requires one court transcript, for example, I mean, maybe that would just take a few months. But if it's a more complicated one that requires many transcripts, like a very long proceeding, or it's one that requires interviewing witnesses. So, for example, the one where I indicated the Justice of Peace was removed from office, that involved sexually inappropriate conduct. And I think in that case, over 30 witnesses were interviewed, and that took a considerable period of time. That one took longer, so that could take, and during the process, he raised a lot of legal arguments. That one took a couple of years.
I'm afraid I need to end that there. Mr. Whalen.
Thank you very much, and thank you to the witness for her public service. It's quite
Thank you.
substantial. The 2015 report that you sent is really interesting. You know, it seems like you're carrying about and resolving about 40 complaints per year through that process. Is that roughly still the run rate now for your office?
Until the annual reports are tabled, I can't give public information out on it. There's a tabling requirement in the legislation. So this is the most recent one that has been tabled, so it's the last one that I can speak to.
Thanks, Ms. King.
And you've seen the numbers in there.
Yeah. So, and Ms. King, were you involved with the administration of the review in Review Council back in 2015 as well?
I've been with the Review Council since January of 2008.
Okay, sorry. Thank you very
So-
much. Okay.
No,
Okay, that's
okay.
great. So the 2015 year, what was roughly the overall cost for administering the Review Council?
Honestly, I don't know that. I'm sorry. I didn't bring that kind of information. I don't know. I'd have to, I
we
wouldn't
wanted
want
to
to, I
get
wouldn't want to
the-
guess at that. I can tell, well, why don't I tell you that, although I don't know the cost, that we are a relatively small office. I'm the only lawyer. There are 2 assistant registrars who are not lawyers, and there is 1 administrative assistant. And these 4 people, we support this council, and I also support an analogous Ontario Judicial Council that takes complaints about provincial judges. So we have to be pretty efficient.
And I'm just not trying to say that we need to skimp on the administration of justice and preservation of the
No,
integrity
no.
of justice. I just want to get a sense of what size of an office we're talking about to administer
Yes.
the process.
Yes.
Because it seems that the number. Go ahead.
I was just going to say, it is a small office. If you were going to actually recommend something, I would recommend maybe you go a little bit bigger, because I am the registrar, so I oversee day-to-day operations. I provide legal advice and legal services to both councils, and I support all of the public hearings. I assist in drafting documents, and I'm the media spokesperson.
So I know you didn't get an opportunity to delve deeply into the structure that we're trying to make some recommendations on, but the IRB has 4 panels: an immigration division, a refugee division, and then an appeals division for each of those. And if I try to draw some analogy, the lower levels of the immigration and the refugee divisions, have roughly the same number of people that the chief justices have. Those folks are all unionized public servants. And then the appeal division would be the governor and council appointments. Do you see any issues that might arise in the context of your review process were the justices of the peace unionized? It's a hypothetical.
I don't think I can answer that question. I'd have to really think about that. I'd be reluctant to answer that off the fly. I'm, after all, a lawyer. I'd need to think about that.
Okay. Fair enough. It's just one of the things that we're coming to and struggling with. I just thought if maybe you had an opinion to be insightful. With respect to the other level, then, the Judicial Council, what are some of the key differences between the procedures you have in place for reviewing judicial misconduct as opposed to justice of the peace misconduct?
It's actually very analogous. I would say the one, well, there's really 2 key differences. The Judicial Council has 1 more level of review. So they have a level of review that does the investigation, and they report to a middle level of review that has 4 members of that council on it. And then if it's ordered to a hearing, it goes to the 3rd level of review. But every level, again, investigation and the review panel in between and the public hearing, all have members of the public, a different member of the public at each level. The other difference is that the Judicial Council does not have available to it the dispositions of advice in person or in writing, and that is a remedy that has been used by the Review Council, but that's not available to the judges.
Okay. Well, it seems then that your office, since it's able to carry both of those, roughly how many, I just want to see how good an analogy the financials might be when we get them. How many judicial appointments are there in Ontario, so that how many people would be subject?
Well, I'm just going to refer to the annual report for that
Perfect.
year, because I think it's pretty similar. So in 2016, for example, there were approximately 498 justices of the peace on the bench, and there would probably be a similar number, like under 400, but more than 300 of judges on the bench. So 300 to 400 of each category.
Fair enough. When we had Mr. Adderman before us earlier in the week, we were trying to get a sense of what type of conduct should come before the disciplinary panel. Typically, it's just code of conduct related matters would be addressed, not issues related to knowledge of the law, because they would be subject to appeal. But if a justice of the peace had demonstrated over a period of time that all of their decisions were being overturned, or they just didn't have the law right, or their competence was beginning to suffer. Would that be something that would come before your body as well?
There was a complaint, although it didn't go through to a hearing because the Justice of the Peace fully retired, and if they leave office, we lose jurisdiction. But there was a complaint that did come forward to start of a public hearing, and it was an allegation of incompetence as a result of a pattern of, I guess, a pattern of incompetence over a period of time, not knowing the law and misapplying the law. So we have seen that, but it didn't go through all the way. And then in a hearing that is, a disposition is pending on it right now. The hearing was fairly recent. The judicial officer made a decision to issue a criminal charge and information for a criminal charge, and a decision to sign off on a subpoena. And the hearing panel found that although those were judicial decisions, the circumstances around that were a cause for concern and shifted it into the realm of judicial misconduct. There is case law that says just because it's decision making, it doesn't mean it's excluded from misconduct.
Fantastic. And when I try to look at the charts in the 2015 annual report, it says 12 were out of jurisdiction, 0 were loss of jurisdiction. So out of jurisdiction would be like the retirements, and would loss of jurisdiction be when the Chief Justice refers something to as a criminal matter and has dealt with elsewhere?
Out of jurisdiction would probably mean that it's strictly decision based. There's no conduct involved in it. And a loss of jurisdiction would mean that they fully retired and they're gone, or they died.
Okay, so would it be possible if there's some type of sexual misconduct alleged against the judge and it goes to criminal proceedings separate and apart for this, both processes would still continue? This would have to be resolved as well as whatever criminal charges. This process would not be halted.
Well, it depends on what the evidence is, but this process would not be prevented because of that. That's correct.
Thank you very much, and I'll get another opportunity to ask some questions about how you feed into training
I think
later.
that's the end, actually. Yes. The notice of the meeting was till 11:45.
Oh, I was told I had to have more.
Yes.
Shoot.
No, you might have. Thank you very much. Want to thank you for your help with our work, and the committee now is going to move to an in-camera business meeting, and thank you for taking the time with us. And
well, you're welcome, and thank you very much for the interest in the council. I really appreciate it. This is the council who actually sent me, so.
Thank you.
Thank you.
Spend for a few moments as we move into in-camera meeting and take a stretch.
you.